I was sitting at my kitchen table, sipping lukewarm coffee and reviewing case files, when my younger brother Daniel burst through the door holding what looked like an official document. His face was flushed, his eyes wide with a mixture of confusion and anger that I immediately recognized from years of growing up together. "Jackson, you need to see this right now," he said, slamming the paper down on the table hard enough to make my coffee mug jump. "These people have lost their minds." I picked up the document and started reading. It was an eviction notice, not just any eviction notice, but one demanding that our family vacate the 23 acres of land in rural Virginia that had been in the Jameson family since 1860. According to the paperwork, we had violated multiple covenants of the newly formed Willow Creek Homeowners Association and had 30 days to remove ourselves from the property or face legal action. "What homeowners association?" I asked, looking up at Daniel. "This land has been in our family for over 160 years. We're not part of any HOA." "That's what I said," Daniel threw his hands up. "But apparently, some developer bought the land adjacent to ours about 6 months ago and built a whole neighborhood. Now they're claiming our property falls within their HOA boundaries." I read through the document more carefully, my lawyer instincts kicking in. The notice cited violations including unsightly agricultural structures, non-conforming livestock, failure to maintain grass height standards, and unpermitted historical buildings. They were referring to our family's original homestead, the barn my great-great-grandfather built with his own hands, and the small cattle operation we'd maintained for generations. "Who signed this?" I asked, looking at the signature line. "Some woman named Patricia Whitmore. She's apparently the HOA president." I pulled out my laptop and started searching for information about this Willow Creek HOA. Sure enough, a development called Willow Creek Estates had been built on the formerly vacant land to the east of our property. The houses were those cookie-cutter McMansions that seemed to be popping up everywhere, all beige vinyl siding and fake shutters. The HOA's website showed Patricia Whitmore as the president, a woman who appeared to be in her early 50s with an aggressive blonde bob and the kind of smile that never reached her eyes. "They can't do this," Daniel said, pacing around the kitchen. "Can they?" "No, they absolutely cannot," I replied, already formulating a strategy. "This is our land. We have the deed, the historical records, everything. We were never part of their development and never agreed to join their HOA. This is either a massive misunderstanding or an intentional land grab." I spent the rest of that afternoon diving into the property records at the county clerk's office. Our family's deed was crystal clear, dating back to 1860 when my ancestor, Jonathan Jameson, purchased the land from the federal government after serving in the military. Every subsequent transfer had been properly recorded, from father to son, generation after generation. There was absolutely no legal mechanism by which our property could have been absorbed into the Willow Creek HOA. The next morning, I drove over to the HOA office, which was located in a small building at the entrance to Willow Creek Estates. The woman at the front desk, whose name tag read Cheryl, looked up from her computer with a practiced smile. "I'm here to see Patricia Whitmore," I said. "Do you have an appointment?" "No, but I think she'll want to see me. My name is Jackson Jameson, and I received an eviction notice from this HOA yesterday." Cheryl's expression changed immediately, a knowing look crossing her face. She picked up the phone and spoke quietly into it, then gestured toward a door. "Mrs. Whitmore will see you now." Patricia Whitmore's office was exactly what I expected. Everything was coordinated in shades of cream and gold, with motivational posters about community standards and neighborhood excellence on the walls. Patricia herself sat behind an oversized desk, her blonde bob perfectly styled, wearing a blazer that probably cost more than most people's monthly mortgage payment. "Mr. Jameson," she said, not standing or offering to shake hands, "I assume you're here about the notice." "That's right," I said, taking a seat without being invited. "I'm here to inform you that your notice is legally baseless and that if it's not withdrawn immediately, I'll be filing suit against this HOA for harassment and attempted illegal seizure of property." Patricia's smile didn't waver. "Mr. Jameson, I understand this may be upsetting, but the fact is that your property falls within the boundaries of Willow Creek Estates. When the development was approved, the county established our HOA's jurisdiction over a specific area. which includes your land." "That's completely false," I said, pulling out the folder of documents I'd brought. "My family's property deed predates your development by over a century and a half. We never signed any agreement to join your HOA. We never received any notification of being included in your boundaries. And frankly, you have no legal authority over our land whatsoever." "I disagree," Patricia said, her voice taking on a harder edge. "The developer's survey clearly shows that your property is within our boundaries. The county approved those boundaries. That means you're subject to our covenants, conditions, and restrictions, just like every other property owner in Willow Creek Estates." "Show me the survey," I said. Patricia hesitated for just a moment, then pulled out a map from her desk drawer. I studied it carefully. Someone had drawn the HOA boundaries in a way that created a small appendage extending west from the main development, specifically to encompass our property. It was clearly intentional. "This is fraudulent," I said. "You can't just draw lines on a map and claim jurisdiction over property that's not part of your development. Did the original landowner own our property when they sold to the developer?" "That's not relevant," Patricia said. It's completely relevant. If the developer never owned our land, they couldn't have included it in the development boundaries. This is an attempted land grab, pure and simple." Patricia leaned forward, her eyes narrowing. "Mr. Jameson, I'm going to be direct with you. Your property is an eyesore. It brings down the value of every home in Willow Creek Estates. Your ramshackle barn, your wandering cattle, your complete disregard for aesthetic standards, it's unacceptable. We're offering you a fair solution. You have 30 days to vacate, and we'll purchase the property from you at market value." "So that's what this is really about," I said. "You want our land." "We want to maintain the standards of our community," Patricia corrected. "Your property doesn't meet those standards." "My property isn't part of your community," I said, standing up, "and it never will be. You're going to withdraw this eviction notice, or I'm going to bury you in legal paperwork. I'm a lawyer. Mrs. Whitmore, specializing in property law. This is exactly the kind of case I live for." For the first time, a flicker of uncertainty crossed Patricia's face. "You're bluffing." "Try me," I said. "You have until close of business today to withdraw the notice. After that, I file suit." I walked out of the office, my hands shaking with adrenaline and anger. This wasn't just about legal principles anymore. This was about my family's history, my heritage, the land my ancestors had worked and lived on for generations. No HOA president with delusions of grandeur was going to take that away. That evening, I received a phone call from a number I didn't recognize. When I answered, a man's voice came through, professional but with an undertone of aggression. "Mr. Jameson, this is Richard Blackwell. I am the attorney representing Willow Creek Homeowners Association." Of course, Patricia had hired a lawyer. I should have expected that. "Mr. Blackwell," I said, "I hope you're calling to inform me that the eviction notice has been withdrawn." "Actually, quite the opposite," he said. "I'm calling to inform you that if you don't comply with the notice, we'll be filing for an injunction to remove you from the property and seeking damages for your continued violations of HOA covenants." "On what legal basis?" I asked. "Your client has no jurisdiction over my property." "The county records show otherwise," Blackwell said. "The HOA boundaries were approved by the County Planning Commission. Your property falls within those boundaries. That makes you subject to HOA rules, whether you like it or not." "I'd like to see those county records," I said, "because I've reviewed the property deeds and there's no legal mechanism by which my land could have been included in your client's HOA without my consent." "The developer owned the land," Blackwell said. "The developer never owned my land," I countered. "Not 1 square foot of it. So how exactly did the developer include my property in their development boundaries?" There was a pause on the other end of the line. "I'll need to review the documents more carefully." "You do that," I said. "And while you're at it, you might want to advise your client about the penalties for filing fraudulent liens and making false legal claims. I'll be filing a complaint with the state bar if this continues." I hung up, feeling a mix of satisfaction and concern. Patricia clearly had resources, and she'd hired an attorney willing to push her questionable legal theory. This was going to be a fight. Over the next few days, I dove deep into the county records. What I found was disturbing. The developer, a company called Greenfield Developments, had submitted a plat map to the county showing the boundaries of Willow Creek Estates. That map included our property, despite the fact that Greenfield had never owned it. The County Planning Commission had apparently approved the plat without verifying the ownership of all the parcels within the proposed boundaries. It was a bureaucratic error, but one with serious implications. The HOA had been formed based on that flawed plat map, and they were now using it to claim authority over our land. I scheduled a meeting with the county attorney's office. The attorney I met with, a harried-looking woman named Susan Martinez, listened to my explanation with growing concern. "This is a significant problem," she said, reviewing the documents I'd brought. "The Planning Commission should have caught this. The developer should never have been allowed to include property they didn't own in their plat." "But they did," I said, "and now the HOA is using that mistake to try to force my family off our land." "We'll need to correct the plat map," Susan said. "That's going to require a formal process, probably a planning commission hearing." "How long will that take?" "Several months at least." "I don't have several months," I said. "The HOA gave me 30 days. "They can't enforce that eviction notice," Susan said, "not while there's a dispute about the property boundaries." "Try telling them that," I said. I left the county office feeling somewhat reassured, but still concerned. The wheels of bureaucracy turned slowly, and Patricia Whitmore struck me as someone who wouldn't wait for the official process to play out. I was right to be concerned. 2 weeks later, I came home to find a notice posted on our front gate. The HOA was fining us $500 per day for every day we remained in violation of their covenants. The fines had started the day after the eviction notice was sent, which meant we supposedly owed over $7,000 already. "This is insane," Daniel said when I showed him the notice. "They can't just make up fines like this." "They can try," I said grimly. "It's another pressure tactic." I immediately filed a lawsuit in state court, seeking a declaratory judgment that our property was not subject to the HOA's authority and an injunction preventing the HOA from taking any further action against us. I also filed complaints with the State Attorney General's office and the Real Estate Commission about the HOA's conduct. The lawsuit got Patricia's attention. Within days of being served, she called a special meeting of the HOA board. I found out about it from a sympathetic neighbor named Thomas, who lived in Willow Creek Estates and was appalled by what the HOA was doing. "Patricia is telling everyone that you're trying to destroy the neighborhood," Thomas told me. "She's claiming that if your property isn't brought into compliance, everyone's home values will plummet." "That's ridiculous," I said. "Our land has been here for over a century. Their neighborhood has been here for less than a year. If anything, our historic property adds character to the area." "I know that, and some of the other residents know that," Thomas said. "But Patricia is very persuasive. She's got most of the board convinced that this is an existential threat to the community." The legal battle escalated quickly. Blackwell filed a motion to dismiss my lawsuit, arguing that the HOA had sovereign authority over its boundaries as approved by the county. I filed a motion for summary judgment, arguing that the county's approval was void because it was based on fraudulent information from the developer. The first hearing was scheduled for early October, about 6 weeks after I'd received the initial eviction notice. I spent those weeks preparing, gathering every piece of historical documentation I could find about our family's property. I had the original deed from 1860, signed by Jonathan Jameson. I had surveys from 1892, 1920, 1955, and 2003, all showing the exact same property boundaries. I had tax records going back generations, all showing that my family had paid taxes on this specific parcel of land continuously for over 160 years. I also gathered evidence about Patricia Whitmore and Willow Creek HOA. What I found was troubling. Patricia had been involved in several other HOA disputes in the past, always pushing for more control and higher standards. In one case, she tried to force an elderly homeowner to remove a wheelchair ramp from his front porch because it violated the HOA's architectural guidelines. In another, she'd attempted to ban children from playing in their own front yards because it looked untidy. The woman had a pattern of overreach, and our case was just her latest crusade. The day of the hearing arrived. I put on my best suit and drove to the county courthouse, a historic building in downtown Fredericksburg. The courtroom was wood-paneled and dignified, with high ceilings and large windows that let in the morning light. Patricia was there with Richard Blackwell, both of them looking confident. Patricia had brought several other HOA board members as well, all dressed formally and sitting together in a show of solidarity. Judge Margaret Harrison entered the courtroom, and we all stood. Judge Harrison was in her early 60s, with gray hair pulled back in a bun and sharp, intelligent eyes. She had a reputation for being fair, but no nonsense, which was exactly what I was hoping for. "Good morning," Judge Harrison said, taking her seat. "We're here today for cross motions in the case of Jameson versus Willow Creek Homeowners Association." "Mr. Jameson, you're representing yourself?" "Yes, Your Honor," I said, standing. "And Mr. Blackwell for the defendant. Let's begin with Mr. Jameson's motion for summary judgment. Mr. Jameson, you're arguing that the HOA has no jurisdiction over your property. Make your case." I spent the next 30 minutes laying out the history of my family's land ownership, walking the judge through every document I'd collected. I explained how Greenfield Developments had never owned our property, how the plat map submitted to the county was fraudulent, and how the HOA's claims were completely without legal foundation. "Your Honor," I concluded, "this is a clear case of attempted illegal seizure of property. The HOA is using a bureaucratic error to try to force my family off land we've owned for over 160 years. They have no legal basis for their claims, and their actions constitute harassment and abuse of process." Judge Harrison nodded, making notes. "Mr. Blackwell, your response?" Blackwell stood, adjusting his tie. "Your Honor, the plaintiff is attempting to relitigate a matter that's already been settled by the County Planning Commission. The commission approved the boundaries of Willow Creek Estates, including the plaintiff's property. That approval gives the HOA lawful authority over all properties within its boundaries. The plaintiff's recourse, if he disagrees with the commission's decision, is to appeal through the administrative process, not to seek relief from this court." "But Mr. Blackwell," Judge Harrison said, "the plaintiff's evidence shows that the developer never owned his property. How could the Planning Commission lawfully approve boundaries that included land the developer didn't own? The Commission's approval is presumed valid, Your Honor. The burden is on the plaintiff to prove it was erroneous." "I think Mr. Jameson has met that burden," Judge Harrison said dryly. "He's produced over a century and a half of continuous ownership records. Do you have any evidence that the developer owned this property?" Blackwell hesitated. "We rely on the county's approved plat map, Your Honor." "Which was based on information provided by the developer," Judge Harrison said. "Information that appears to have been false. This is a serious matter, Mr. Blackwell. Your client is attempting to exercise authority over property they have no legal claim to." "Your Honor, with respect, the HOA was formed in good faith based on the county's approved plat. If there was an error in that process, the HOA shouldn't be penalized for relying on official government records." Judge Harrison leaned back in her chair, studying both of us. "Here's what I'm going to do. Mr. Jameson, I'm granting your motion for a temporary injunction. The HOA is hereby prohibited from taking any enforcement action against your property, including fines, liens, or eviction proceedings, pending resolution of the boundary dispute. However, I'm not going to grant summary judgment at this time. I want the county involved in this case. I'm going to order the County Planning Commission to conduct a hearing to review and correct the plat map for Willow Creek Estates. Once that process is complete, we'll revisit the jurisdictional question." It wasn't a total victory, but it was enough. The injunction meant Patricia couldn't continue harassing us while the legal process played out. "Thank you, Your Honor," I said. Patricia looked furious as we left the courtroom. She tried to approach me in the hallway, but Blackwell pulled her back, whispering urgently in her ear. Over the next few weeks, I thought things would calm down. The injunction was in place, the county was reviewing the plat map, and surely Patricia would realize she was fighting a losing battle. I was wrong. One evening in late October, I was in the barn feeding our cattle when I heard shouting from the direction of the house. I ran outside to find Patricia Whitmore standing in our driveway, flanked by two other HOA board members I didn't recognize. "This is private property," I said. "You need to leave." "We have every right to be here," Patricia said, holding up her phone. I'm documenting violations for our legal case. There is no legal case, I said. The judge issued an injunction. You can't take any enforcement action against us. I'm not taking enforcement action, Patricia said with a cold smile. I'm simply documenting the current state of the property. Look at this barn. It's falling apart. And those cattle, they're not properly fenced. What if they get out and damage property in Willow Creek Estates? Our cattle are properly fenced, I said, trying to keep my temper in check. They've been on this land for generations and have never caused any problems. That's not what our residents say, one of the other board members chimed in, a thin man with a pinched face. We've had complaints about noise and smell. You've had complaints about cattle being cattle, I said. Look, I've tried to be reasonable about this, but you're on my property without permission. I'm asking you to leave. If you don't, I'll call the police. Go ahead and call them, Patricia said. We're not doing anything illegal. I pulled out my phone and dialed the local sheriff's department. Within 15 minutes, a deputy arrived. I explained the situation, showing him the court's injunction and explaining that these individuals were trespassing on my property. The deputy, a young man named Officer Collins, listened carefully and then turned to Patricia. Madam, do you have permission to be on this property? We're HOA representatives conducting a legitimate inspection, Patricia said. This property isn't part of your HOA, Officer Collins said. The owner has asked you to leave. You need to go. This is ridiculous, Patricia said, but she was already backing toward her car. We'll see what the judge has to say about this. After they left, Officer Collins turned to me. You might want to consider putting up no trespassing signs, maybe a gate with a lock. These HOA disputes can get nasty. Yeah, I'm learning that, I said. The next day, I installed a locked gate at the entrance to our property and posted clear no trespassing signs. I also set up security cameras covering the driveway and the area around the barn. If Patricia was going to continue harassing us, I wanted everything documented. The County Planning Commission scheduled a hearing for mid-November. In the meantime, I continued gathering evidence. I discovered that Greenfield Developments had a history of shady practices. In 2 other developments in neighboring counties, they'd been accused of misrepresenting property boundaries and selling lots they didn't actually own. In one case, they'd settled a lawsuit for a significant sum. I also learned more about how our property had ended up on Willow Creek's plat map. It turned out that the developer's surveyor had made what he claimed was an honest mistake, incorrectly including our parcel in his boundary survey. But the more I dug, the less accidental it looked. The surveyor had worked on all of Greenfield's projects, including the ones where they'd been accused of boundary fraud. I filed a formal complaint against the surveyor with the state licensing board. I also reached out to the families affected by Greenfield's previous schemes, gathering affidavits about the company's pattern of misconduct. The Planning Commission hearing was held on a rainy Tuesday evening in November. The commission consisted of 5 members, all local residents appointed by the County Board of Supervisors. They sat behind a long table at the front of the room, with a stenographer to one side and a screen for displaying documents on the other. I arrived early and set up my presentation materials. Patricia was there too, along with Blackwell and what looked like a dozen residents from Willow Creek Estates. They'd clearly organized a show of force, hoping to sway the commission with numbers. The commission chair, an older gentleman named Robert Fletcher, called the meeting to order. We are here tonight to review the approved plat map for Willow Creek Estates, specifically regarding the inclusion of a parcel owned by the Jameson family. Mr. Jameson, you brought this matter to our attention. Please present your case. I walked the commission through everything I'd learned. I showed them our family's continuous ownership records dating back to 1860. I displayed the fraudulent plat map that included our property, despite the developer never owning it. I presented evidence of Greenfield Development's pattern of similar misconduct in other projects. I even had affidavits from 2 of the other families they had defrauded. The conclusion is inescapable, I said. The plat map for Willow Creek Estates was based on false information deliberately provided by the developer. My family's property should never have been included in the HOA boundaries, and that error needs to be corrected immediately. Robert Fletcher nodded gravely. Mr. Blackwell, does the HOA have a response? Blackwell stood. The HOA was formed in good faith based on the approved plat. The The residents of Willow Creek Estates purchased their homes relying on the boundaries as shown on that plat. To change those boundaries now would be unfair to those homeowners who bought property expecting certain standards to be maintained throughout the development. But sir, one of the commission members interrupted, a woman named Jennifer Oates, the standards you're talking about enforcing would apply to property you don't have any legal claim to. How is that fair to Mr. Jameson? The county approved the plat, Blackwell said. That approval established the HOA's boundaries. Based on false information, Jennifer said. If we approved something based on fraudulent data, we have a responsibility to correct that error. The commission then opened the floor for public comment. One by one, residents of Willow Creek Estates stood up to complain about our property. They claimed the barn was an eyesore, the cattle were noisy and smelly, and our land was bringing down their property values. I paid $400,000 for my home, one woman said, her voice shaking with emotion. I chose Willow Creek Estates because of its standards and its beautiful uniform appearance. Having that farm right next door completely destroys the aesthetic we were promised. That farm was here 160 years before your neighborhood, I couldn't help saying. You bought a house next to a historic property. You don't get to erase that history just because you don't like the way it looks. Patricia was the last to speak. Commissioners, this isn't just about one property. It's about the integrity of our entire community. If Mr. Jameson is allowed to disregard our standards, what message does that send to our other residents? What's to stop everyone from letting their properties fall into disrepair? We have rules for a reason, and those rules need to apply to everyone within our boundaries. But Mr. Jameson isn't within your boundaries, Robert Fletcher said firmly. That's the whole point. His property was never part of your development. The plat map was wrong. The commission deliberated for less than 20 minutes. When they returned, Robert Fletcher read their decision. The commission has reviewed all the evidence presented tonight. We find that the plat map for Willow Creek Estates incorrectly included a parcel of property not owned by the developer at the time the plat was submitted and approved. This was a significant error that should have been caught during the approval process, but was not. The commission hereby orders the plat map to be corrected to remove the Jameson property from the boundaries of Willow Creek Estates. The HOA has no jurisdiction over that property and never did. This decision is effective immediately. Relief washed over me. Finally, an official ruling that put an end to Patricia's harassment, or so I thought. As I was packing up my materials, Patricia approached me, her face flushed with anger. "This isn't over," she hissed. "I'll appeal this decision. I'll take it all the way to the state Supreme Court if I have to." "You'll lose," I said calmly. "You've lost already. My property is not part of your HOA. It never was. Accept it and move on." "You've destroyed this community," Patricia said. "Every homeowner in Willow Creek Estates has suffered because of your selfishness." "I haven't done anything except defend my family's legal rights," I said. "Maybe you should spend less time trying to control other people and more time accepting that the world doesn't revolve around your HOA." I thought that would be the end of it. The Planning Commission had ruled, the court's injunction was still in place, and surely even Patricia would recognize that she had no legal ground left to stand on. But I had underestimated her determination, or perhaps her obsession. 2 weeks after the Planning Commission hearing, I received notice that the HOA was appealing the Commission's decision to the County Board of Supervisors. Blackwell filed a lengthy brief arguing that the Commission had exceeded its authority and that the original plat approval should stand. I filed a response brief, pointing out that the Board of Supervisors had the authority to correct errors made by the Planning Commission and that the evidence of fraud by the developer was overwhelming. The board scheduled a hearing for January. In the meantime, the holidays arrived. My family had always celebrated Christmas on our land, gathering in the old farmhouse that my great-great-grandfather had built. We'd string lights on the barn, set up a tree in the living room, and spend the evening telling stories about our ancestors who'd worked this same land. This year felt different, though. There was a shadow hanging over everything, the uncertainty about whether we'd be able to keep our home. Daniel tried to stay positive, but I could see the worry in his eyes. Our mother, who lived in Richmond and visited regularly, was openly anxious. "I can't believe this is happening," she said on Christmas Eve, standing in the kitchen where she'd grown up. "My father was born in this house, his father before him, and now some stranger thinks she can just take it away from us? She can't, I said, with more confidence than I felt. The law is on our side. The facts are on our side. We're going to win this. But doubt gnawed at me. Patricia had resources and determination. She'd already spent what must have been tens of thousands of dollars on legal fees. How far was she willing to go? I got my answer in early January. I received a certified letter from a company called Summit Property Group, offering to purchase our land for $3 million. The letter was professional and carefully worded, but the message was clear. Take the money and go away. I did some research on Summit Property Group. They were a development company based in Northern Virginia, and their CEO was Patricia Whitmore's husband, Gregory Whitmore. It all clicked into place. This had never been just about HOA standards or property values. Patricia and her husband wanted our land. They wanted to develop it, to build more cookie-cutter McMansions and make a profit. The HOA dispute was just a pressure tactic, a way to try to force us to sell. I felt my anger rising, cold and focused. This wasn't just legal harassment anymore. This was corruption, a deliberate scheme to defraud my family of our property. I called the county attorney's office and asked to speak with Susan Martinez again. When I explained what I'd discovered, there was a long silence on the other end of the line. That's a serious allegation, Susan said finally. You're saying the HOA president is using her position to try to force you to sell your land to her husband's company. That's exactly what I'm saying, I replied, and I have the letter to prove it. Send it to me immediately, Susan said. This could be criminal fraud. I also called the state attorney general's office and spoke with an investigator named Marcus Thompson. He listened to my story with growing interest. We've been looking at HOA abuses for a while now, Marcus said. This could be part of a larger pattern. Can you send me everything you have? Over the next few weeks, I worked closely with both the county attorney and the state AG's office, providing them with every document I'd collected. They started their own investigation, subpoenaing records from both the HOA and Summit Property Group. What they found was stunning. Patricia and Gregory Whitmore had done this before. In another county, they'd used a similar scheme, having Gregory's company develop a neighborhood and then having Patricia, as HOA president, target adjacent properties with harassment and violations until the owners agreed to sell. They had acquired 3 properties that way, developed them, and made a substantial profit. The Board of Supervisors hearing in January became irrelevant. The county attorney filed a formal complaint against Patricia Whitmore for fraud and abuse of her position as HOA president. The state AG opened a broader investigation into Summit Property Group's business practices. In February, Patricia was arrested. I watched the news that evening, seeing her being led out of her house in handcuffs, her face shocked and pale. Gregory was arrested the same day at his office in Alexandria. The charges were serious: fraud, conspiracy to commit fraud, extortion, and abuse of position. The prosecutor's case was built on the pattern of conduct they had established, targeting property owners adjacent to their developments and using HOA authority as leverage to force sales. The arrest made headlines throughout Virginia. Other property owners who'd been targeted by Patricia started coming forward, adding their stories to the growing pile of evidence. The HOA that Patricia had run with such an iron fist quickly distanced itself from her, with the board voting to remove her as president and issuing a public apology to my family. Richard Blackwell withdrew from the case, claiming he'd been misled by his client about the true nature of the dispute. The new HOA board, led by Thomas, the sympathetic neighbor who'd first warned me about Patricia's tactics, formally acknowledged that our property was not and had never been part of Willow Creek Estates. In March, I received a formal letter from the HOA's new attorney, apologizing for the harassment my family had endured and offering to pay our legal expenses and compensate us for our time and distress. I accepted the offer, not because I needed the money, but because it was an official acknowledgement that we had been wronged. The criminal trial for Patricia and Gregory Whitmore was scheduled for June. As the date approached, their attorneys tried to negotiate a plea deal, but the prosecutor wasn't interested. The case was too high profile and the evidence too strong. I attended the trial, sitting in the public gallery and watching as the prosecution methodically laid out their case. They called the 3 other property owners who'd been forced to sell to Summit Property Group. They presented emails between Patricia and Gregory discussing strategy for pressuring us to sell. They showed financial records proving that Summit Property Group had made over $2 million in profit from the properties they'd acquired through these schemes. The defense tried to argue that Patricia had genuinely believed our property was part of the HOA and that any contact with us about selling had been separate from her HOA duties. But the jury didn't buy it. The evidence was too damning, the pattern too clear. In late June, the jury returned guilty verdicts on all counts. Patricia and Gregory Whitmore were each sentenced to 4 years in federal prison and ordered to pay restitution to all the property owners they'd defrauded. Standing on the courthouse steps after the sentencing, I felt a complex mix of emotions. Relief, certainly. Satisfaction that justice had been served. But also sadness that it had come to this, that someone's greed and desire for control had caused so much harm. A reporter from the local news station approached me, asking for a comment. "This case is about more than just one HOA dispute," I said. "It's about the importance of property rights and the dangers of allowing anyone, even an HOA, to have unchecked authority. My family held this land since 1860. We survived the Civil War, 2 world wars, the Great Depression, and countless other challenges. We weren't about to let an HOA president with delusions of grandeur take it away from us." The story ran that evening, and I received calls and emails from people across the state who'd had their own disputes with overreaching HOAs. Some of them asked me to represent them. I took on several cases, finding a new specialty in HOA law that I'd never expected. By August, life had returned to something resembling normal. The gate at the entrance to our property came down, no longer necessary. The security cameras stayed up, though, a reminder of what we'd been through. Daniel and I stood on the front porch of the farmhouse one evening, watching the sun set over the fields our ancestors had worked for generations. "Do you think we'll ever sell this place?" Daniel asked. "Not in my lifetime," I said. "And not in yours either, if I have anything to say about it. This land is part of our family's story. It's who we are." "Patricia and Gregory almost took that away from us," Daniel said quietly. "They tried," I said, "but they failed. Because no matter how much money or power someone has, they can't take away your rights if you're willing to stand up and fight for them." The case had taught me something important about the law and about justice. The system isn't perfect. It can be slow, frustrating, and expensive. But when you have the truth on your side and the determination to see it through, the system works. Over the following months, I continued to receive updates about the fallout from the case. Willow Creek Estates underwent a significant change in culture. The new HOA board, led by Thomas and other reasonable residents, revised the covenants to be less restrictive and more focused on genuine community concerns rather than aesthetic micromanagement. They reached out to us, inviting us to neighborhood events and treating us as valued neighbors rather than problems to be solved. Some of the residents who'd been most vocal in supporting Patricia's crusade against us quietly moved away, embarrassed by their role in the affair. Others apologized, explaining that they'd been misled by Patricia's persuasive rhetoric about property values and community standards. I accepted their apologies. Holding grudges wasn't going to accomplish anything, and many of them had genuinely not understood the legal and ethical problems with what Patricia was trying to do. The surveyor who'd prepared the fraudulent plat map for Greenfield Developments lost his license after the state board's investigation. Greenfield Developments itself filed for bankruptcy after being hit with multiple lawsuits from property owners in their other developments. The whole scheme had collapsed like a house of cards once the truth came out. In September, the county held a ceremony to recognize our family's long history on the land. The Board of Supervisors presented us with a historical marker to be placed at the entrance to our property, commemorating the Jameson family's residence since 1860. My mother attended, along with several aunts, uncles, and cousins. We took photos by the marker, 5 generations of Jamesons standing on the land that had sheltered and sustained our family for over a century and a half. I thought about Jonathan Jameson, my great-great-great-grandfather, who'd first claimed this land after serving his country. What would he think if he could see us now? Would he be proud that we'd fought to keep what he'd built? I like to think he would be. The legal bills from Patricia's fraud case went to a victim compensation fund, and my family received a check for $50,000, covering our legal expenses and compensating us for the stress and disruption we'd endured. I used part of it to restore the old barn, the same barn Patricia had called an eyesore. We hired a historical preservation contractor who specialized in 19th-century agricultural buildings, and over the course of 3 months, the barn was carefully restored to its original condition while being reinforced to meet modern safety standards. The restored barn became something of a local landmark. The contractor nominated it for inclusion in the National Register of Historic Places, and in December, we received notification that the nomination had been approved. Our family's barn was now officially recognized as a historical treasure, protected by federal law. I couldn't help but smile at the irony. Patricia had called our barn an eyesore and demanded we tear it down. Now it was a protected historical structure, more permanent and secure than any of the vinyl-sided McMansions in Willow Creek Estates. In early winter, I attended a legal conference in Richmond focused on property rights and HOA law reform. The Whitmore case had become something of a cause célèbre in legal circles, an example of HOA overreach taken to its criminal extreme. I was invited to speak on a panel about defending property rights against HOA abuse. Standing at the podium, looking out at an audience of attorneys, judges, and legal scholars, I told our story. I talked about the importance of historical property ownership, about the dangers of giving HOAs too much unchecked authority, and about the need for vigilance against those who would use their position for personal gain. The law is a powerful tool, I said in conclusion, but it only works if people are willing to use it. My family could have given up when we received that eviction notice. We could have accepted the buyout offer and walked away from our heritage. But we chose to fight, and in doing so, we not only protected our own rights, but exposed a pattern of fraud that had harmed multiple families. That's the power of standing up for what's right, even when it's difficult, even when it seems easier to just give in. The audience applauded, and several attorneys approached me afterward to discuss their own HOA cases. I exchanged business cards and promised to consult on their matters. What had started as a personal fight to protect my family's land had evolved into a broader mission to help others facing similar injustices. As another year passed, the memory of the dispute faded, but never disappeared entirely. The experience had changed me, making me more aware of how easily rights could be threatened and how important it was to remain vigilant. I kept copies of all the legal documents from the case, not out of paranoia, but as a reminder of what we'd overcome. Daniel got married that spring, holding the ceremony on our land under an ancient oak tree that had stood there since before Jonathan Jameson first arrived. As I watched him exchange vows with his bride, I thought about continuity, about the importance of place in history. This land had witnessed births and deaths, celebrations and sorrows for over 160 years. It would continue to do so, hopefully for generations to come. My mother planted a garden that summer, choosing the spot where her own mother had once grown vegetables to feed the family during hard times. Watching her work the soil, I saw the same determination that had sustained our family through everything we'd faced. It was in our blood, this connection to the land, this refusal to give up what was rightfully ours. The new HOA board from Willow Creek Estates occasionally consulted with me on legal matters, wanting to ensure they stayed within proper boundaries and didn't repeat Patricia's mistakes. I was happy to help, seeing it as an opportunity to build the kind of positive relationship between neighbors that should have existed from the beginning. Thomas became a good friend. He told me once that he'd moved to Willow Creek Estates looking for community, for a place where he could put down roots. Patricia's aggressive management style had turned the neighborhood into something more like a police state than a community. With her gone, the residents had a chance to create something better, something based on mutual respect rather than rigid rules and harsh enforcement. One evening in late summer, I drove out to the old cemetery on the edge of our property where generations of Jamesons were buried. I found Jonathan's grave, the stone worn but still legible. I told him about everything that had happened, about Patricia's attempt to take our land, and how we'd fought back and won. It felt right to share the story with him, to let him know that his descendants had protected what he'd built. The sun was setting as I walked back to the farmhouse, casting long shadows across the fields. The cattle were settling down for the night, their occasional lowing a familiar and comforting sound. In the distance, I could see the lights coming on in Willow Creek Estates, each house glowing in the twilight. We existed side by side now, the old and the new, history and progress. It didn't have to be a conflict. There was room for both, as long as people remembered to respect each other's rights and boundaries. I thought about writing a book about the experience, a detailed account of how an HOA dispute had escalated into criminal fraud and what lessons could be learned from it. The story deserved to be told, not just for my family's sake, but for all the other property owners who might face similar challenges. Knowledge was power, and the more people understood about their rights, the harder it would be for anyone to abuse their authority the way Patricia had. But that was a project for another day. For now, it was enough to stand on my family's land, free from threats and harassment, knowing that we'd stood up for what was right and won. The eviction notice that had started this whole ordeal was framed and hanging in my office, not as a trophy, but as a reminder of the importance of defending your rights, no matter who challenges them or how powerful they seem. As I climbed the steps to the farmhouse porch, I felt a deep sense of peace. This land had seen conflict before and had endured. It would continue to endure, sheltering future generations of Jamesons, standing as a testament to the simple but profound truth that some things are worth fighting for. The lights were on in the kitchen, and I could smell dinner cooking. Daniel and his wife were staying with me for a few days, and we'd planned a family dinner. Tomorrow we'd ride out to check the fences in the north pasture and make sure the cattle had enough water. The day-to-day work of maintaining the property never stopped, but that was how it should be. The land required care and attention, and in return, it provided sustenance, stability, and a connection to history that no HOA could ever replicate or replace. I thought about Patricia Whitmore, sitting in a federal prison cell, her schemes exposed and her freedom taken away. I didn't take joy in her imprisonment. I felt satisfaction that justice had been served. She'd tried to use her position to enrich herself at others' expense, and she'd paid the price. The system had worked, slowly and imperfectly, but it had worked. The case had attracted attention from state legislators, who were now considering new laws to regulate HOAs more strictly and provide better protections for property owners. I'd been asked to testify before a legislative committee about our experience and what reforms I thought were necessary. It was an opportunity to turn our ordeal into something positive, to help create systemic changes that would protect others from similar abuse. As I sat down to dinner with my family, passing plates and sharing stories, I felt grateful for everything we had. The land, the history, the bond between us that had been strengthened by adversity. Patricia had tried to tear us down, but instead, she'd made us stronger. The story of how an HOA sent an eviction notice for land my family had held since 1860, and how I used my legal training to fight back and expose corruption, would become part of our family's oral history, passed down to future generations. They would learn from it the importance of standing up for your rights, of not being intimidated by those who abuse authority, and of the power of knowledge and determination in the face of injustice. The land stretched out beyond the windows, dark under the night sky, but still ours, still home. Jonathan Jameson had claimed it in 1860, and his descendants would hold it for generations to come. No HOA, no matter how aggressive or corrupt, would change that fundamental truth. As dinner wound down and we moved to the living room for coffee, Daniel raised his cup in a toast. "To family," he said, "and to never giving up what's rightfully ours." "To family," I echoed, clinking my cup against his, "and to the land that sustains us." Outside, the night was peaceful. The cattle were quiet, the fields were still, and the old farmhouse stood solid and enduring as it had for over a century and a half. Tomorrow would bring new challenges, new work to be done, but tonight we could rest in the knowledge that we'd faced a serious threat and prevailed. The legal battle was over, the criminals were punished, and our property rights were firmly established. But more than that, we'd proven something important, that ordinary people, armed with knowledge and determination, could stand up to those who tried to abuse power and win. That was a lesson worth more than any amount of money, more valuable than any piece of property, no matter how historic. As I headed to bed that night, I paused at the window of my bedroom, looking out over the land that had been the center of my family's life for so long. The moon was rising, casting silver light over the fields and making the barn's new roof gleam. Everything was as it should be, peaceful and secure. I thought about all the Jamesons who'd looked out this same window over the years, watching the same moon rise over the same fields. I was part of a continuum, a link in a chain that stretched back to 1860 and would hopefully continue far into the future. That was something worth fighting for, worth defending against anyone who threatened it. Sleep came easily that night, deep and dreamless. The weight of uncertainty that had pressed down on me for months was finally gone. Our land was safe, our rights were protected, and justice had been served. Tomorrow would be a new day, free from the shadow of the HOA dispute, free to focus on the important things, family, history, and the timeless rhythm of life on the land. The story had a happy ending, but it was also a cautionary tale. HOAs served a legitimate purpose when properly managed, but they could also become instruments of oppression and corruption in the wrong hands. Vigilance was necessary, both from homeowners who needed to watch for abuse and from legislators who needed to create proper oversight and accountability. I'd done my part, not just in defending my own rights, but in exposing a pattern of criminal conduct that had harmed multiple families. The reforms being discussed in the state legislature would make it harder for future Patricia Whitmores to abuse their authority. That was a legacy worth having, something that would outlast me and benefit people I'd never meet. As weeks turned into months and the calendar moved toward a new year, life on the farm continued its ancient patterns. Seasons changed, cattle were born and sold, crops were planted and harvested. The work was hard but satisfying, connecting me to the land and to the generations who'd done the same work before me. The historical marker at our entrance became a point of pride for the whole county. Tour groups sometimes stopped to read it and take photos, learning about the Jameson family's long history on the land. A local historian wrote an article about us for a regional magazine, tracing our family's story from Jonathan's original land claim through all the changes and challenges of the intervening years. The HOA dispute was mentioned in the article, but only briefly, as the most recent challenge the family had overcome. In the broader sweep of our history, it was just one more obstacle, no more significant than droughts, economic depressions, or wars. We'd endured, as we always had, protecting what was ours and passing it on to the next generation. That was the real story, not the legal battle or the criminal trial, but the simple fact of continuity, of maintaining a connection to the land across generations. In an age of constant change and disruption, that kind of stability was increasingly rare and increasingly precious. I made peace with the experience, recognizing that while it had been difficult and stressful, it had also taught me valuable lessons and opened up new opportunities in my legal career. Sometimes the challenges we face, the ones that seem unbearable at the time, turn out to be blessings in disguise, forcing us to grow and discover strengths we didn't know we had. The last time I drove past Willow Creek Estates, I noticed that several of the houses had small gardens in their front yards, something that would have been forbidden under Patricia's strict aesthetic rules. The neighborhood looked more lived in, more human, less like a magazine spread, and more like a real community. It was a small change, but a significant one, a sign that the residents were creating something better than what Patricia had imposed on them. Our barn stood proudly on the horizon, its historical marker gleaming in the sun. The contrast between the restored 19th century structure and the modern subdivision couldn't have been more stark, but somehow they coexisted peacefully, the old and the new, tradition and progress, each respecting the other's right to exist. That was how it should be, I thought. That was the lesson from all of this. We don't have to choose between honoring history and embracing the future. We can do both, as long as we remember to respect each other's rights and boundaries, to follow the law, and to stand up against those who would abuse their authority for personal gain. The story of the Jameson family's land would continue long after I was gone, hopefully for many more generations. New chapters would be written, new challenges overcome, new triumphs celebrated. But the foundation would remain the same. A piece of land claimed in 1860, held through good times and bad, and defended when necessary against those who sought to take it away. That was our heritage, our story, our identity. No HOA would ever change that. Patricia Whitmore had learned that lesson the hard way, and her attempt to seize our property had backfired spectacularly, exposing her crimes and landing her in prison. Justice had been served, rights had been protected, and the land endured. As I pulled into our driveway that evening, past the historical marker and through the gate that no longer needed to be locked, I felt a profound sense of contentment. The fight was over, the victory was complete, and life could return to normal. But I would never forget what we'd been through, and I would always be ready to defend our rights again if necessary. That vigilance, that determination to protect what was ours, was as much a part of our family legacy as the land itself. It had been passed down from Jonathan through all the generations that followed, and I would pass it on to my children when the time came. The land and the will to defend it were inseparable, two parts of the same inheritance. The sun was setting behind the barn as I walked up to the farmhouse, painting the sky in shades of orange and gold. Another day was ending, another chapter closing, but the story continued. It always had and always would, as long as there were Jamesons willing to work the land, protect it, and pass it on to the next generation. That was the true meaning of home, not just a place, but a commitment, a responsibility, a sacred trust. We were the stewards of this land, temporary guardians of something much larger and longer lasting than ourselves. Understanding that, honoring that, was what gave life meaning and purpose. I stood on the porch for a long moment, looking out over the fields one last time before going inside. The land was quiet and peaceful, exactly as it should be. Our fight was over, our victory secure, and the future stretched out before us, full of possibility and promise. Whatever challenges might come, we would face them together, as a family, on the land that had sustained us for over 160 years and would continue to do so for generations to come.